My name is John Spangenberger, and I'm a partner here at Lando Anastasi's Electrical and Computer Arts Group. Much of the work in our practice area touches on software-based technologies. And despite the importance of software in an increasingly digital world, inventors and practitioners alike remain frustrated with the lack of clarity around patent eligibility under 35 U.S.C. 101. This year marks the 10-year anniversary of the Supreme Court's Alice decision, and little has been done to clarify patent eligibility jurisprudence in the past decade. Indeed, just last week at the time of recording, the Supreme Court denied a petition to examine an appeal from the CFAC in real-time data versus array networks. That case, and Judge Newman's dissent in particular, exemplifies the current state of affairs in 101 jurisprudence. Judge Newman lamented that the issues arose under Section 112 as enablement issues, not Section 101 patent eligibility issues. This is a familiar frustration for practitioners accustomed to arguing about what is routine and conventional in a Section 101 analysis, issues that would seemingly be better suited for analysis under Section 102 or Section 103. Judge Newman truly had her finger on the pulse with the conclusion of her dissent, arguing that we should stop wading into the morass that is current patent eligibility analysis. But as confusion continues to grow in the judiciary, clarity may be brewing in the legislature. The bipartisan Patent Eligibility Restoration Act, introduced in the Senate in June of 2023, formally acknowledges the confusion and lack of consistency in dealing with patent eligibility with the U.S. Patent Office and with the courts. The Act proposes to remove judicial exceptions to patent eligibility altogether, albeit while amending Section 101 to recite some exceptions already familiar to practitioners. Mathematical formulas, purely mental processes, natural materials, and human genes will remain unpatentable. Also excluded from eligibility will be processes that are substantially economic, financial, business, social, cultural, or artistic, if those processes can practically be performed without a machine or manufacturer. Now, naturally, some confusion will arise from this language. For example, when is a process substantially social, and when can an artistic process practically be performed without a machine or manufacturer? But nonetheless, many provisions of the Act will be a breath of fresh air to practitioners and patentees alike. The Act states that patent eligibility will be considered without any regard whatsoever to whether a claim element is routine or conventional, without any regard to any prior art, and if that wasn't clear enough, then without any other consideration to Sections 102, 103, or 112. If the Act is passed, then gone will be the days that we need to argue about what is routine and conventional in the context of 101. Of course, that's a big if as to whether the Act will be passed and whether it would survive constitutionality challenges. Legislative aides affiliated with the Act hastened to remind us that patent legislation often takes at least 10 years to be enacted. But with the current state of affairs with patent eligibility jurisprudence in the judiciary, help from the legislature would be better late than never.